Indemnity and indemnification are scary sounding words that are pretty intimidating. Indemnity clauses are very common in commercial real estate leases and contracts. In a real estate indemnity agreement, one party is pledging to protect the other party from some kind of financial loss or from a lawsuit of some kind related to the property. So in this presentation, we'll discuss first why this clause is important, why we should care about the indemnity clause. Then we'll take a look at a sample indemnity clause, and then finally we'll wrap it up with some suggestions and some tips for you to consider to help you understand your commercial real estate lease better. Indemnity clauses are very important because they shift risk between the parties. In 1976, Led Zeppelin released a song called Nobody's Fault But Mine. In that song, Robert Plant sings of a man coming to realization of his own mortality and acknowledging that in trying to save his soul tonight, it's nobody's fault but mine. It's common sense to think that a party should be responsible for their own actions and negligence, but indemnification clauses can change that. Indemnification clauses assign risks between the contracting parties that might not otherwise be assigned to that party. Because of this, they require the parties to think about what-ifs and try to determine ahead of time who will be responsible for some sort of a calamity, loss, or accident on the property. There are lots of losses that can occur on a property. For example, fire, water damage, rain, tornado, flood, high winds, falling trees, hail, cars that might plunge into a building, or even eminent domain, a street widening or a sidewalk expansion. And of course, there's slip and fall cases or other property casualty claims. So indemnity and the concept of indemnification apportions the risk of these losses between the parties. The tenant may be responsible for some, while the landlord might be responsible for some others. Additionally, indemnification clauses often contain an agreement to defend. This is a provision that creates or requires one of the parties to defend the other party in a lawsuit. This means paying for their legal counsel as well as your own legal counsel during some sort of litigation or lawsuit involving the property. And indemnification clauses often contain what's called a hold harmless provision. This prevents the party who gets stuck with the indemnity bill from suing the other party who gets indemnified. So to avoid any surprises or getting stuck with some legal bill from the other party, it's very important to pay attention to your indemnity provision and seek appropriate counsel, legal counsel in particular, before you sign an indemnity clause. Indemnity clauses can be very lengthy and contain multiple paragraphs. However, I pulled a simple one off the internet that we'll take a look at now. This example deals with the tenant indemnifying the landlord. In other words, the tenant under this provision will be responsible for making the landlord whole for the losses that occur under the lease that are covered by this particular indemnity provision. Here you'll see that not only does the tenant have the obligation to indemnify the landlord, but also the obligation to protect, defend, and hold harmless the landlord. In other words, the tenant is going to be paying for the legal representation of the landlord in any case that's implicated under this particular indemnity clause. The losses covered under this clause include personal injury, bodily injury, death, or property damage for incidents occurring both on the premises, presumably the leased premises, as well as the project other than the premises. So for example, somewhere else in the building, or perhaps it's common areas that are going to be covered by this indemnification clause. That's a fairly typical example of a tenant indemnity provision. Now let's offer a few suggestions for how to deal with these indemnity provisions. The determination of who is responsible for a loss under commercial real estate lease is quite a complex legal interpretation, and indemnification clauses further complicate things by attempting to shift risk between the parties. Unfortunately, indemnification clauses are prevalent throughout the industry and are likely going to be here to stay. Because of their complexity, and because of the likelihood that they could shift the risk of loss to an unsuspecting party, it is very common to have legal counsel review and draft and negotiate indemnification clauses, as well as to have one's insurer examine the clause and make sure that the insurance coverage is going to be adequately crafted to make sure that the loss is covered. Indemnity provisions in commercial real estate leases and contracts are very tricky. However, they are very important. It's a good idea to have legal counsel review commercial real estate leases and contracts, and in particular to pay close attention to provisions such as the indemnity provision. However, we hope that this presentation has been helpful to you and will help you better understand your commercial real estate lease or contract, including the indemnity provision. So, to summarize, be aware of the risk-shifting potential of the indemnity provision and pay attention to language that is going to assign other risk to you. In a perfect world, you should be responsible for nobody's fault but your own. This presentation is for general information purposes only. It is not to be construed as providing any advice, whether legal, real estate, tax, or otherwise.